you have the floor.
All right. Thank you very much, Josephine. And I'd like to appreciate the conveners of this meeting, this important platform, the Zimbabwe Environmental Law Association, my former colleagues, of course. I'll introduce myself. My name is Darlington Chidarara. I'm a projects coordinator with Action Aid International in Zimbabwe. And I lead the work that Action Aid Zimbabwe is doing under natural resource governance, and in particular, mineral resource governance. So mine really, I think, is not a very difficult task. I'm just going to give you the background to business and human rights in Africa. So I will just switch my video so that I don't strain my bandwidth as well as some of yours. I just showed my video so that you can see who you are talking to, right? So allow me to do that, and then I can just dive into the background, right? Let me just maybe begin with a teaser, a brain teaser, some facts that are alarming. I'm not sure if the students who are here are aware of these statistics, but did you know that 2/3 of the world's economic entities are corporations? What that means is that the world's economy is driven by corporates. Yeah, so this should not really excite you at all. This should worry you, because what that translates to is that the corporates have a lot of power in terms of deciding what happens to the economy. Remember, the corporates are profit-driven, never people-driven. And that means that they then have leverage, not only to you as individuals that operate with the corporates, but also even to the countries where they are operating. That means the corporates have the power to actually control the states. So today, in many ways, ladies and gentlemen, that same motive to grow profits above everything else, of course, continues to drive many businesses and many business activities on this beautiful continent of Africa. Now, often corporations, as I've already mentioned, have become larger and become more powerful than the countries that they operate in. So in a recent survey that was done, it was highlighted that 100 of the richest entities by revenue, a full 69, of course, are not actually countries, but companies. So what that means is that as we are talking about issues to do with these corporates, if you look at the corporates such as Walmart, Shell, Apple, they've become richer than some of the countries that used to be some of the richest countries. We're talking of countries like Russia, Belgium, Sweden. Now, let's just talk about the smaller nations of Africa. Can you imagine how these corporates are rich as compared to these smaller states in the global south? So basically, if you look at the companies such as Apple, I know you love iPhones, I know you love your MacBooks, but just the market value of that company, of Apple, has surpassed $1 trillion United States dollars, which is roughly equal to the combined GDP of Africa's 5 largest economies. Yeah, once again, I think that should send a chilling message down your spine. And why do I do that? Let's look at the history of when Europe made contact with Africa, so that we understand this subject more. So in fact, we often say that colonization as we know it was created by 3 C's. No pun intended to my Zimbabwean comrades. The 3 C's are the corporates, the church, and the crown. So those are the 3 C's I'm talking about. To be clear to my Zimbabwean comrades, I know triple C means something else to you. Okay, so the corporates in Africa have a long history of profiting from the exploitation, of course, from our resources as well as our people. Remember slave trade. So beginning in 1500, companies arrived on the continent with special charters which were issued under the authority of their own European states. So remember, the European states had met and done what they called the scramble and partition of Africa. So the states also issued these special charters to these corporates who were coming to explore. And what did these charters employ? These charters allowed them to trade goods within specific regions. And they also gave these companies the power to use whatever means necessary, including violence, just to make sure that they access or they advance and sustain trade in these areas. So these are states, these are corporates which have been given so much power over Africa so that they can advance and sustain their trade. So in fact, we saw a number of corporates such as to my brothers in South Africa and Zimbabwe, you would know the Imperial British East Africa Company or the Dutch East India Company, and many other players that then became very pertinent or that had an integral role in colonization of Africa for the centuries that would come later on. Let me just bring it to bring it home, maybe to Zimbabwe, the history that we also understand, which also somehow identifies with the Zambian students who are here in the webinar. So if you look at the Zimbabwean history during the 1980s and 1880s and 1890s, we saw the British South Africa Company initiating colonization of Zimbabwe. It was, of course, backed by also the Royal Charter from Queen Victoria. We saw Cecil John Rhodes, who, of course, was the pioneer of Zimbabwe's colonization with his British South Africa Company, bringing a written concession and signing a written concession for exclusive mining rights in Matabeleland and other adjoining territories from King Lobengula through the signing of the Rat concession. When he arrived, of course, later with an army, he then declared a war on the same king that he had bought or allegedly bought these exclusive mining rights from. And then it was a done deal. That's how Zimbabwe was colonized. In 1890, we saw Zimbabwe being a company colony. Of course, it was then later on annexed into the British state system, but it had all began from the contacts of Zimbabwe and these corporates. So basically, you can realize that historically, international, the corporates have had so much power when it comes to not just trade, but also influence on states. So looking at this history and the power that the corporates host today, you realize that today, corporations that include the mining companies, we're talking of agro-businesses and the textile manufacturers, or even some of the biggest energy companies are in a situation where they are still responsible for major human rights abuses and violations on the continent. We are talking of environmental damage, we're talking of labor practices, any other land rights related challenges, and multiple other human rights violations at the hands of the corporates. So historically, if you look at our international human rights law, it has only governed states as subjects of international law in that sphere, of course, which bear obligations to those within their jurisdictions. However, I think with the background that I have given of the corporates that are doing their businesses in Africa and the experience that we have had as some of the CSOs who work directly with communities, we have realized that the increasingly powerful nature of corporates and the extent to which they often oversee greater resources, thus hold more power than sovereign states, have given rise to the core to incorporate the operations of the corporations within international human rights law. I think this is what then has brought us where we are today, or this has prompted the need for maybe a legally binding instrument or a treaty on business human rights. So what is this culminated into? So we saw in 2014, South Africa and Ecuador jointly sponsoring a resolution before the United Nations Human Rights Council, which brought to establish an intergovernmental working group to work towards the drafting and passing of a binding treaty on business and human rights, so that the multinational trans corporations can have obligations and can be governed through international law. And I think since 2014, we have seen the group being quite busy drafting and also facilitating the negotiation process towards signing such a binding treaty. So I think this basically is the background. If you look at the background and the history of how the corporates have always had that upper hand, and how the corporates have always sort of had impact and influence, not just on individuals, but on the states themselves, from where they were coming from to where they were going, and the power that they have managed to have up to today. Definitely, there is need that we dilute corporate power if we want to avoid a situation where the corporates operate with total impunity. So in brief, in short, I've been given 10 minutes. In short, I think this can be a good background where you can start thinking of the issues to do with business and human rights within the African context. I think we can then just take it further as a discussion. Let me leave it from here, and if there are questions, we'll address questions later. Thank you, and over to you, Josephine.
Thank you very much, Darlington, for such a background on the history of companies, human rights on the continent in Zimbabwe and Zambia. Thank you very much. I think you can utilize the question and answer chat, the one written Q&A, to ask any questions that you might have for Darlington. And when we do the plenary, Darlington can address those questions. And if you have a burning question that you have, you can raise your hand, and I can allow you to speak and ask Darlington a question. And at the moment, I don't see any question in the chat. I think maybe the questions will come after the other presenters have made their presentations. So I will, in the meantime, move on to the next panelist, Michelle Chitando, who is going to talk to us about some of the norms that have been put in place to address the issues of business and human rights, their legal status, if any. And before she'll give the general overview before we can get down to Chairman's presentation specifically on the African human rights system. So Michelle, over to you.
Hi, Josephine. Just 2 minutes. There's a bit of noise on my side.
Okay, that's all right. I think there's a question there. We can have Darlington. Okay, there is a question from Fatima, who asked, how can states hold these multinational corporations liable where there is breach of human rights? This is a very important question. And I don't know, Darlington, do you want to answer? Or this is something that can be also answered by the coming presentations?
Thanks very much, Josephine. I can briefly respond. So
Okay.
if we look at different legal systems that we have in our different countries, we have starting with the supreme laws, which is the Constitution. Our constitutions, mainly from Southern Africa or any other constitutions, they give obligations to the state entities and individuals. Of course, this then means that the companies as juristic persons are also bound by the Constitution to ensure that they promote, protect, and make sure that they respect human rights. So the Constitution is always the first point of call where there are human rights violations, because most of our modern constitutions have what we call the Bill of Rights. So you'll find that this will always be the first point of call. And of course, then it depends with which country you're from. You may have other supporting legislation that you can use, of course, if you are challenging the corporate power within your legal systems, that is through the courts. So I think that that would basically be the first point of call. But I'm sure the other presenters, Chairman as well as Michelle, are going to touch on this, and this question will be answered more in depth. Thank you. I hope you are answered, Fatima.
Okay, thanks, Darlington, for that brief overview. I'm sure Michelle and Chairman's presentations will also assist in shedding more light on the subject matter. Michelle, are you ready to give us your presentation? Okay.
Yes, I am. Yes, I am.
Okay.
Josephine, and thank you, Darlington, and welcome to all the participants who managed to join us today. My name is Michelle Chitando. I'm a legal officer with the Zimbabwe Environmental Law Association. I am also part of the Responsible Investments in Business Programmatic Management Unit, where the discussion for today squarely lies. So you'll forgive me for not having a PowerPoint, which I will send after this because I'm juggling between two conferences happening at the same time. There's a climate and development conference being hosted by the UZ and other entities. So I was in that one, but I'll quickly get back. But I have my PowerPoint. I'll share it with Josephine, and then it will be shared on the email or whichever platform for you to be able to interact. Thanks to Darlington, who made a very elaborate background to the issue we're discussing today. My topic is to discuss the norms and future prospects of business and human rights in Africa. I think we all know that we have a history of dealing with business, or a lot of issues emanating with business interacting with human rights. So for example, we've seen a lot of socio-economic violations happening within areas where business is interacting with people on the ground. For example, we've seen of labor violations, labor rights violations, for example. I'll give a classic case of what happened in Marikana, where 44 people died and over 70 people were injured. This arose as a dispute over unfair wages, and also the community saying we're not receiving any dividends from what the mining company is extracting, and it was becoming an issue. We've seen also occupational health and safety issues. For example, in Zimbabwe, the 2020 Auditor General's report revealed that there are poor working and health and safety conditions in the mining sector in Zimbabwe. We've also seen community land rights violations. I think Darlington spoke about it when he mentioned that we've seen displacements of communities, because in a lot of the African countries we have, communities are domiciled on communal land, and communal land in most cases is either vested in the president, or the communities don't have extensive rights, and as a result, they are either inadequately compensated or there isn't any compensation at all. We've seen environmental degradation, be it soil, water, air pollution. We've seen issues of corruption, for example, poor governance within the institutions that are within the businesses operating in the various sectors, corporate opacity, for example, we don't know their financial data, the lack of disclosure of such, and poor governance mechanisms generally within the companies that are operating. I think lastly, just to paint the whole picture of the lack of corporate social responsibility, climate change concerns, we're talking about companies greenwashing. They're saying they're doing something to reduce their emissions, but it turns out they're actually not, or they're contributing to the climate problems that we're having. So you'll see that within the contemporary context, we have an interaction of business and human rights, where people now are becoming aware that in as much as you are here to make profit, you cannot make profit without being considerate of the human rights or the people that are already within the vicinity that you're operating within. So we know that business definitely will not want any binding regulation or will not see it as a necessity. But when it becomes something that is binding, as Darlington has spoken about, we're working towards a legally binding instrument, inevitably businesses will have to comply. So you'll find that the root cause of a lot of these business and human rights issues comes from globalization, the scope and impact of economic forces and actors, or even the capacities that we have to monitor these things have evolved over time. And in other instances where we've got weak state institutions, there is more of putting the investors or profit or economic development over the human rights of the people on the ground. But then it's now where we begin to discuss instruments, or where we're saying what are the norms and what is the future prospect of business and human rights in Africa. So my presentation is really going to be based off of the United Nations Guiding Principles on Business and Human Rights. We really just want to think about, in as much as our countries have national laws to deal with issues of business and human rights, we've seen countries such as Kenya, Tanzania, Zambia, Zimbabwe, for example, coming up with national action plans on business and human rights. What we're trying to do is to say, how can we now shape an Afrocentric concept, for example, around business and human rights through the existing instruments, for example, the United Nations Guiding Principles on Business and Human Rights, which I will call UNGPs for short, and the other systems that Chairman is going to speak about, the already existing platforms that we have for promotion and protection of human rights. So I would like to assume that I'm speaking to people who are already aware or they're converted to say on what the guiding principles on business and human rights are. But basically, these are three interconnected pillars that talk about the state's duty to protect its citizens from rights and abuses of third parties, the corporate responsibility to respect the human rights of citizens in their operations, and the availability of an access to remedy where the human rights abuses occur. So the UNGPs really basically lay out a framework that is aimed at preventing and addressing human rights violations where they occur at the incidence of business activity. So basically, we're looking at the state's existing obligations to respect, protect, and fulfill human rights, fundamental freedoms. And then now when we speak specifically about business and human rights, that's the role of business enterprises as specialized organs of society performing a specialized function, and they're now required to comply with the applicable laws and to respect human rights. This is where we're looking at the issues of due diligence, for example. What is happening within the value chain of within the business? We're talking about issues of responsible sourcing, for example. Is there any child labor involved within the business? Products or whatever materials that they're using within their business value chain is not sourced where human rights violations have occurred. This has become the topic of discussion to say, back in the day, the companies would just say we're operating within the framework that's provided by the countries, within which they're operating in. But we're saying companies now need to take a positive or an active duty towards complying with applicable laws and to also respect human rights. The third part of the UNGPs is really the need for rights and obligations to be matched with the appropriate and effective remedies when breached. So we've spoken about, the socio-economic problems that are there to say if, for example, a company has displaced communities in a particular area, be it for mining purposes, they want to build a block of flats or whatever enterprise they want to get into. We're saying there should have been a respect of human rights by the company in terms of providing compensation, in terms of providing relocation mechanisms, or to see where they're supposed to be. This would come in from the framework of the state to say, is there an outline to make sure that the rights of the people are respected, protected, and fulfilled? But also, more importantly, where the companies fail to do that, or where it's not very clear, there should be an available and an effective remedy for the human rights violations of the people who are affected to be able to claim such. That is going to court, clearly outlined laws to say you can approach this tribunal, you can approach this court, which is what Chairman will really speak about in terms of the systems that are already available within the African context, where we're looking at business and human rights issues. So what have we seen really when we're talking about future prospects of business and human rights in Africa? There has been an incidence of cases being filed where we are using the UNGPs as a form of getting a remedy or bringing the business enterprises to account. I will make reference to a case where Lide and Buisa Molele, which are UK and South African based law firms respectively, announced an intention in 2019 to bring a class action lawsuit against Anglo-American South Africa on behalf of claimants in Kabwe, a town which is located in central Zambia, with a long history of lead and zinc extraction. So the action was filed in October 2020 in the South African High Court. And these law firms really were seeking compensation for persons suffering from lead poisoning, and then alleging that Anglo-American South Africa was responsible. So the central issue that the court has had to really certify was, can we say that the applicants are saying the source of the lead is from Broken Hill Mine, which is a mine that this company was operating under? Can we also then say that most of the lead that has been produced over the mine's lifespan? And also through the class action, the applicants sought compensation, saying that the respondents had a duty of care to protect them and to also protect the future generations against the risk of lead pollution arising from the mine's operation. I seek to get confirmation on this, but from the 31st of January, the judgment was still pending and certification was to be concluded. But basically, this is what we're seeing as a trend when we're looking at issues of business and human rights. Whilst there are not many cases around business and human rights, but this is the thinking where we're trying to say rights are involved, communities are involved, and businesses involved. Was there a duty of care? Should due diligence have been taken? What was the company supposed to do? And is there an access to a remedy should these things not have been followed? So it's the thinking around this when we're looking at shaping an Afrocentric human rights approach to business and human rights using the existing legal instruments that are available to us, to start to interrogate the duties that businesses have when we're looking at their interaction with communities, to begin to interrogate further than to say, this is the direct link of what happened and what the communities have faced, but beginning to really break down the duties that corporates have in terms of the UNGPs, to start to put them into practical use, to say, if you were an enterprise that has been operating, you were supposed to comply with applicable laws and you were supposed to respect human rights. So from a perspective of really broadening that duty that business enterprises have, it's now specifically looking at the duties that the corporations have and then starting to apply it to the violations that might have occurred or are likely to occur. Because we wouldn't want an instance where we continue to have violations of human rights just because businesses are coming in within a particular community, or they are doing their business as would be expected. Again, businesses are not just there to make profit. We really need to make sure that there is some benefit, or that respect for human rights is really respected, and these businesses should support and respect internationally recognized human rights, and they are not complicit to human rights abuses. They should also be taking a precautionary approach to environmental challenges, for example, and should undertake to work against corruption in all its forms. So we're saying, let's look at the role that businesses have, or the corporate responsibility to respect human rights. Let's begin to break it down. And if cases are to be brought before the courts, we're now beginning to see how this duty can really be implemented or really be applied practically when we want to protect the human rights of the different communities that we have. So the duty to respect human rights applies to all forms of business, as I've said. It's not just in the mining sector, it's also any other company. If you are manufacturing cell phones, for example, what is your financial data like, for example? Do you also make sure that there is equality and non-discrimination within your company? What policies do you have for environmental protection? What governance issues do you consider as being key and important to your business, for example? What environmental safeguards are you using within your company? Are you reducing your plastic use, for example? Is your waste management in compliance with the laws that are particularly within the country that you're operating in? So it's not necessarily to say it applies to one sector, but trying to apply that respect for human rights in all businesses and seeing how they work towards respecting the human rights that are there. So issues of human rights due diligence, as I've said, is to make sure that they seek to prevent or mitigate adverse human rights impacts that are directly linked to their operations. So the business relationships that they have, which partners are they working with? Who's in the value chain? Are they working effectively with state or non-state actors? And basically, what policies are they putting in place to make sure that they respect human rights? And also, what is the due diligence being done in terms of making sure that these policies, or to put in place these policies, is being done within the particular company? I think I would like to stop here. I was given 20 minutes to make a presentation. I don't know if there are any questions, if we're taking them now or if we're taking them after the last presentation. Over to you, Josephine.
Thank you very much, Michelle, for that presentation about the responsibilities of business and everything that has been happening in developing within the sector. I just want to also mention that whilst the UNGPs, as Michelle mentioned, are not legally binding, they are principles, like in the name. And as Michelle mentioned, there has been instances where courts have been trying to incorporate the UNGPs within their decision making. So this is something that maybe the young minds here will also be able to help us as we are trying to develop the discourse and the jurisprudence on business and human rights. From the chat board, from the question and answer chat, I see an issue about instruments binding business to actually be. How effective is it? Not states' responsibility? Should instruments not be aimed? I think the question is looking at the liability of businesses, like the direct liability of businesses when it comes to business and human rights. So for that question, I'll pack it until the end of our discussion, such that when chairman has presented, it can also be made clear. So there are no questions directly for you, Michelle. I'm sure they'll come up. Please continue to be connected. There is a question for Darlington. We'll give him a time to respond once chairman has completed his presentation. So chairman, the floor is now yours to make your presentation. And I'm sure some of the issues and aspects mentioned in the questions will be clarified. So over to you, chairman.
Thank you so much, Josephine. And I would like to say good morning to everyone. I do have a PowerPoint presentation, and we'll try to share the screen before I proceed.
Okay, yeah, please feel free to share the PowerPoint presentation. I'm sure you have been given the right to do so. Okay, yeah, we can see your screen.
Okay, and just a sec. All right. So I'm just going to display my camera first so that those who have not seen me can see me. So I'm Chairman Okoloise. I've been serving as senior legal expert at the African Commission on Human and People's Rights, based in Banjul, the Gambia, which is the premier human rights promotion and protection body in Africa. I do have expertise in human rights, so I speak from a very authoritative point of view. Having done my undergrad long essay in human rights, my master's thesis in human rights, and my PhD thesis in human rights, and having worked in mostly human rights institutions. I have adapted the topic a little bit to be more relevant to the discourse rather than what I was particularly given by the organizers. And so I like to start by thanking the Zimbabwe Environmental Law Association for this special invitation. It is a huge honor and privilege for me to be speaking about the relevance of the African human rights system to the business and human rights discourse. And just before going into that, I would like to warn that this topic is an advanced topic. So maybe perhaps since we're talking to undergraduates, it would be important to clarify that when we talk about business and human rights, the current international human rights scholarship focuses on companies and human rights, not just all businesses. Because like you know, business is defined as commercial activity, but in these commercial activities, you have a sole proprietorship, you have partnerships that may be registered or not registered, you have companies, and in companies you have companies that might be limited by, or unlimited. And of course, you might have non-profit focused companies. So when we talk about business and human rights, we're basically talking about companies, particularly companies that are involved in the business of profit making from the sale of goods and services. So I thought I would clarify that. So business and human rights essentially has to do with that aspect of international human rights law that is focused on the relationship between business, that is companies, and their impacts on human rights, whether adverse or positive. And when we talk about the African human rights system, we are basically talking about the systems of norms, standards, and institutions established for the promotion and protection of human rights in Africa. So the entire gamut of norms, as has been elaborated by Darlington and Michelle, and the institutions responsible for ensuring that states comply with their obligations are what make up the African human rights system. And the African human rights system operates at a regional level. So at the international level, you have the UN system, which is global, and then you have the African human rights system, which is regional, and it operates under the superstructure of the African Union. And of course, before you begin to talk about the domestic, that is states and local. So I thought I would clarify this. My presentation is quite straightforward. And since it is somewhat advanced, I thought I would try to explain as we go along concepts that I use so that the students can actually follow methodically. So I've designed here a 4-point structure with an introduction. Then I'll focus next on the relationship between the AU and business enterprises, because the African human rights system, as I've stated, operates under the superstructure of the African Union. And then before I talk about the African human rights system and businesses and whatever relationship it has with businesses, thereafter I'll conclude. I have deliberately chosen different colors for this agenda so that those following the presentation will know when I have transitioned to a new subhead. So you can see the introduction is green, the next topic is purple, and the third one, the African human rights system, is somewhat orange, and then the conclusion is blue. So when you see the presentation, you're going to see these color presentations. I'm following that tone. So as based on the presentation, based on the introduction that I have given, it is pertinent to state that very often within the international human rights system, it is not often considered that businesses are correlated with either international or regional governance structures. So I talked about the UN being a global governance structure, and then the African Union being the regional governance structure for Africa. So basically, because these structures are intergovernmental in nature, that is, they are set up by states, as a form of a loose arrangement or umbrella, and there's no central functioning or legislative authority. They are considered to be intergovernmental, and they only function to the extent to which states have given them power. So for example, the UN, you have a Secretary General and a Secretariat existing in the US and in Geneva. Then you have the African Union existing in Ethiopia. And of course, it has other organs existing in other parts, like the African Commission based in Banjul. So it is not often considered that at the time states set up these bodies, these intergovernmental bodies, they were expected to directly regulate the activities of corporations. That is what the old scholarship has told us. But as we have come to realize over the last 22 years or thereabout, that even though the international treaties setting up these bodies do not expressly or may not expressly mention businesses, they are not excluded from the governance authority of these bodies. So it is on this basis that I will show you how the AU's governance authority extends to businesses, and how within the context of the African human rights system, it is considered that businesses, that is corporations, have human rights obligations. Michelle has stated that under the United Nations Guiding Principles on Business and Human Rights, 3 pillars have been established within which the business and human rights discourse is undertaken. One is the state's duty to protect human rights. That one is mostly understood, that the Zimbabwean government has human rights obligations. It has obligations to promote the rights of Zimbabweans or every individual, whether or not they're citizens, within the territory of Zimbabwe. It has an obligation to respect the rights of every individual within the territory of Zimbabwe, and it has an obligation to fulfill its human rights obligations with respect to individuals living in Zimbabwe. Now, that duty of states is well understood. Now, the second pillar of the UNGPs talks about the corporate responsibility to respect. Now, for a student, if I were still an undergrad student, the question I'll ask myself is, what is now the distinction between a responsibility and a duty? So I will say that that distinction is a distinction without a difference that has been developed by Western international human rights scholars to whittle down the liability of businesses. That is why you will not see in the UNGPs any language of accountability. The UNGPs, even though they sound sweet, they are not intended to hold companies, strictly speaking, accountable. However, they provide guidance for states to hold businesses accountable. Please understand the distinction there. The UNGPs are not designed to hold businesses accountable, but they are designed to provide guidance to states to hold businesses accountable. And that is why there is the use of the corporate responsibility to respect human rights, and then the state's duty to protect human rights. And then, of course, like Michelle stated, you have access to remedy as a third pillar. But within the African human rights system, this distinction is not there. And that is why I say it is a distinction without a difference that has been negotiated and developed by Western scholars to favor the current dynamic of difference between countries of the global north and countries of the global south, and how companies from countries of the global north exploit, the natural resources of countries of the global south without accountability. So that is why the language is different, and it's problematic. I always make that clarification so that you understand that it might sound good, but for Africans who have always been at the receiving end of human rights abuses by transnational corporations, the conceptualization of the corporate responsibility to respect human rights as a non-binding obligation is problematic for African victims. And just as part of my introduction as well, I want to say that the reason why the African human rights system does not adopt this loose, flowery language of the UNGPs is because under the African human rights system, particularly the African Charter on Human and People's Rights, 1981, the Charter does not provide for a lacuna, unlike the UN human rights instruments. The UN human rights instruments are entirely state-centric and are considered to not anticipate direct regulation for that lacuna. This is because under the African Charter on Human and People's Rights, even though there is no direct reference to businesses, the African Commission on Human and People's Rights has interpreted that there is an implied obligation, not a responsibility, but, and I make these three assertions in my introduction, that businesses fall squarely within the normative and institutional governance authority of the African Union and the African Human Rights System, even though sometimes they are not expressly mentioned. It's within also this context that I state that the African Human Rights System does not allow for a lacuna in the protection of human and people's rights. And it's within the same context that I am states that the African human rights system is not designed to African Charter. It only talks about state obligations. But however, when you look very closely within the provisions of the African Charter on Human and People's Rights, particularly Articles 27, 28, and 29, you will see the language of duties individuals. My conceptualization is that the language of individuals within the context of the African Charter must be interpreted to include legal, natural individuals, and legal individuals. So natural individuals would be you and I, individuals, and legal individuals are companies. And if you want to confirm this, you can look at the provisions of Section 2, subsection 2 of the Constitution of Zimbabwe 2013, which says that the supremacy of the Constitution extends to natural and juristic persons, that is natural individuals. So when I talk about individuals, it's within that context. And you can also look at the provisions of sections 44 and 45 sub 2 of the same Zimbabwean Constitution. Now, I know that this is a long presentation, but I will try to keep it. I think that as undergrads, it's very important for you to understand, this foundation, especially the foundation that's built by Darlington and Michelle, but also understanding the intricacies, why it is not just voodoo scholarship to say that there is a relationship between business and human rights. You need to actually have a strong appreciation of why businesses have human rights obligations. Now, to establish the AU's authority, before I go to the African human rights system, the African human rights system, like I said, operates within the AU's superstructure. So the relationship has been very clear. So I'm not trying to draw very abstract connections, and I will prove it. One is that if you look at AU instruments, besides the constitutive as one of the principles and objectives of the African Union is the promotion and protection of human rights under the African Charter. The AU has consistently, throughout its establishment, made references to business or private sector, which suggests that it contemplates that businesses fall squarely within its normative and institutional authority. And one such example is the statutes of the Economic, Social, and Cultural Rights Council, which is an organ of the African Union. You will see that as part of the composition of the ECOSOC, you have employers of labor, that is companies, and then you have the private sector. So that is also businesses. And of course, you have state-owned companies, which are public sector in a way. So all of these is suggestive that businesses are considered to fall squarely within the normative authority of the African Union. But I want to particularly mention some standards. Okay, but before I talk about the standards, I want to justify why is it relevant to even consider that businesses fall within the normative authority of the African Union. There are two reasons why. Unlike in the United Nations, where I talked about the loose language, and many African countries did not contribute to that language. We did not contribute to it. We don't have the diplomatic clout or the resources to undertake the level of diplomatic sophistry that is being undertaken by Western countries. So many international human rights treaties adopted at the level of the United Nations have weak African states' contribution. However, one of the reasons why, like I say, the normative standards adopted at the African Union level with respect to human rights do not have the same level of complexities and nuances that international human rights standards adopted at the UN level might have, for two primary reasons. One is because many African countries, particularly almost all African countries, have the same history of colonial domination and slavery. So as a result of that, there's a unique ability of the AU to act as a platform for narrowing ideological conflict and building consensus based on our shared history. Secondly, is the ability of the AU to adopt continent-wide norms and make binding policy decisions through the AU Assembly and other organs. So these two elements make the African system, the African regional system, very unique for setting standards that apply to business and human rights. And as you will see, since 2000, the AU has consistently exercised decision-making authority over all categories of persons, including businesses. There's been no exception. And you can see this through its establishment in 2005 of the African Private Sector Forum. In 2015, the establishment of the African Economic Forum for African Business. And you see also the development of a continental business network at the level of the African Union, and a contemplated establishment of an African Business Council at the level of the African Union. So all these are pointers to suggest that the AU's normative governance extends to businesses. Just quickly, I would like to mention specific AU instruments that reference human rights conduct by businesses. So for example, you have Executive Council Decision 424 on private sector development, which called on the private sector, in quote, to pursue good corporate governance, socially responsible business practices, transparency, and the respect of laws, rules, and regulations. You also have the Solemn Declaration on the 50th anniversary of the OAU and AU, which reiterated the need for the African private sector to ensure socially responsible business, good corporate governance, and inclusive economic growth. And of course, you also have some important standards adopted at the level of the AU, of course, with the support of the United Nations Economic Commission for Africa, UNECA, in Addis Ababa, in 2009, which is the African Mining Vision. And pursuant to the African Mining Vision in 2019, the AU adopted African Minerals Governance Framework as a framework for implementing the African Mining Vision. And lastly, you have a similar UN-styled, UN Global Compact-styled body called the African Mining Vision Private Sector Compact, which requires extractive companies in Africa to commit to a set of 12 principles for operating in the mining goals to show the exercise of normative authority. So I'm going to my third point before the conclusion, the African human rights system and businesses. So this one is, this aspect is very, very important. And I would like to ask all the students to pay attention. As I will be talking about standards that will be relevant for your notes. So now, what is the African human rights system? So I've said it's the system of norms, standards, and institutions, or you can just say norms and institutions established for the promotion we were talking about things like the guiding principles at the UN level. But at the African level, you have the African Charter on Human and People's Rights, which is like the grand norm, you know, for human rights promotion and protection on the continent. And then you have supplementary protocols adopted to protocol, for example, that is the protocol to the African Charter on Human and People's Rights on the Rights of Women in Africa, 2003. Then you have the protocol to the African Charter on Human and People's Rights on the Rights of Persons with Disabilities. And you have protocol to the African Charter on Human and People's Rights on the rights of elderly people in Africa. So you also have the protocol to the African Charter on Human and People's Rights on the establishment of an African Court on Human and People's Rights. So there are a number of protocols that have been adopted pursuant to the African Charter, and all of these are relevant to business and human rights. So I thought I would list some of these here. But why are these standards relevant to businesses? Why are they relevant? They're relevant because in the African Charter, and traditionally so, there is a vertical relationship between the state and individuals. So states have always been the primary violators of human rights, like governments, you know, during riots and demonstrations, you know, governments committing arbitrary arrests, government committing arbitrary killings, summary executions, you know. So it's always been government. Sorry, not yet there. So it's always been government violating human rights. So there is a vertical relationship. So vertical means top down. You have the state and you have the individual. This means that states have an obligation, states assume obligations under international law, whether they're assuming those obligations under the African human rights system or under the UN system. And those obligations are to be observed in relation to the individual. So that's a vertical relationship. However, under the African human rights system, and which is unique, you also have a horizontal relationship between individuals. So this means that in Africa, we understand that individuals, one individual here, has a responsibility to respect the rights of other individuals. That is, the individual has a responsibility to the other individual, has an obligation to the other individual to respect the right to life of the individual, the right to dignity of the individual, the right to fair hearing, the right to freedom of expression. And you see this every time. Now, as I've explained to you, when we talk about the individual, we're looking at the natural and juristic individual, the natural and legal individual. So that horizontal relationship means individual to individual, or individual to company, or company to individual, however you want to look at it. There is a horizontal relationship. So this means that a company cannot give an order to security personnel assigned to its office to kill someone else. That would be a violation of the right to life by the company. A company, in cases of summary dismissal for misconduct, needs to grant fair hearing to its employee. That is a horizontal obligation. A company has a right of freedom of expression by issuing out public releases and all that. So as students, you need to understand that this level between individuals and many rights we can name here that companies have obligations. Now, I want to say something about this horizontal relationship. There's something that you need to understand there. Where there is a right, there is a responsibility or obligation to respect right. It's called a correlative responsibility. Because if you have a right to life as an individual, then there is an obligation on the part of any other person who can violate that right. That is on the part of the state or on the part of a company or any other individual to not violate your right. So that is called a correlative duty. Where there is a right, there is a correlative duty. And you can see this in the provision of Article 8, Subarticle 2 of the South African Constitution. And of course, even Section 2, Subsection 2 of the Zimbabwean Constitution. I think it's Section 2, not Article of the South African Constitution, Section 8, Subsection 2 of the South African Constitution. So that horizontal responsibility exists on that plane. So this is how it works. And it's on the basis of this that the idea of corporate obligation to respect human rights at the African regional level is recognized. So I thought I would make that point very clear. Now, standards within the African Charter. So the provisions of Articles 2 to 18 of the African Charter on Human and People's Rights has to do with the rights of individuals, while the provisions of Articles 19 to 24 have to do with the rights of peoples. Now, I need to make something clear, that in the African Charter, it is called African Charter on Human and People's Rights, not African Charter on Individual and Collective Rights. There's a reason. That is because they are considered together, human and people's rights. They're not differentiated, but they're not one and the same thing. What it means is that individuals walk into their communities with their individual rights to enjoy group rights. That is how the African Commission has interpreted it. So it's human and people's rights. You have the right to property, for example, yes. But if you go to Article 21, there is a right of peoples to natural resources, to freely dispose of their natural resources. There's a right to freedom. There's a right to a general satisfactory environment suitable to their development, Article 24. And if you go to Article 16, 17, you'll see the right of the individual to the best attainable standard of physical and mental health. So all of these rights are connected one to one another based on the principle of interdependence of human rights, interdependence, interconnectedness. So human rights, you don't just take one right and as a mutually exclusive right. No, they're all together. And so within the context of the African Charter, you have human and people's rights. And these rights are relevant to the obligations that they create, not just for the state, but also for businesses. So I don't want to spend a lot of time on this, but I just want to mention that with respect to supplementary protocols, there has been specific references to businesses. For example, if you look at the African Women's Protocol, that is the Maputo Protocol, Article 13, I and L, you will see that there's a reference to non-discrimination against women by employers or private sector. If you look at the African Disability Rights Protocol, Article 5.1, it says that companies must allow persons with disabilities to make their own decisions, especially people who might have psychosocial disability. Then if you look at the Older Persons Protocol, Articles 4, paragraphs F and G, 19, sub Article 2E, and Article 7.2B and 9.2B, they also create obligations for companies. So these will begin to tell you that as supplementary protocols made to the African Charter, they're also relevant to the discourse on business and human rights. However, the African Charter itself does not specifically make reference to businesses, but I will come to the point where the Commission has stated that businesses have implied obligations under the African Charter. I'm coming to that. It is through soft law, because the Charter itself does not say that does not expressly state that businesses have human rights obligations. The Commission has adopted soft law over the years, various soft laws, to show that in the African Charter, the obligation to respect human and people's rights is firmly implied. And one of such soft laws was adopted in 2018. That is the State Reporting Guidelines and Principles on Articles 21 and 24 of the African Charter relating to the extractive industries, human rights, and the environment. In that particular state reporting guidelines, the African Commission stated that extractive industries, that is extractive companies, have the legal obligation to respect human rights guaranteed in the African Charter. So it's in quote. And the basis of that interpretation is the provision of Article 27 of the African Charter. So Article 27 says that the rights, everyone has a duty to respect the rights of other individuals. So I told you about the horizontal relationship. Article 27 of the African Charter establishes the horizontal relationship. But for the state reporting guidelines, do see paragraph 56, where it is expressly stated that extractive industries have the legal obligation to respect human rights. I see that time is running out. But I also thought that it would be relevant to emphasize that in 2019, the African Commission was very emphatic during the negotiation of the current legally binding instruments on transnational corporations and other business enterprises at the UN level. When it made its own contribution in the form of an advisory note, the African Commission stated, and I quote, "Under the African Charter, obligations of business enterprises towards rights holders have a clear legislative basis. Article 27 of the African Charter provides for the duties of individuals, and its sub-provision 2 lays down the obligation to exercise rights with due regard to the rights of others." That is that horizontal obligation again. Clearly, if this obligation can be imposed on individuals, there is an even stronger moral and legal basis for attributing these obligations to corporations and companies. So you see, the Commission is saying, even though a company is not expressly mentioned in the African Charter, there's a clear legal basis in Article 27 of the Charter to attribute obligation. So you see here, the Commission does not adopt the language of the corporate responsibility to respect. It says there's a clear legislative basis for the obligation of companies to respect human rights. In other soft law instruments such as General Comments 3 and 4, you will see that the African Commission recognizes the responsibility of private military and security corporations, as well as non-state actors such as companies, to respect human rights in Africa. So it's good there. For example, with respect to private military and security corporations, there's legal liability under the Charter for the arbitrary deprivation of a person's right to life in the territory of a state. So what does that tell you? That even though under Article 4, so the right to life is provided for under Article 4 of the African Charter, there's no express mention of the company having the obligation. But the Commission is saying that it's implied there. There's a liability. The company instructs security operatives servicing it to kill people because it wants to have access to resources. There is a clear obligation. So I hope that during your moods, you would find some of these provisions relevant for articulating your points. So the next point I would want to quickly run through is even the guidelines on the right to water in Africa. So the right to water, if you go through the African Charter, there is no specific provision in the right to water. The African Commission has held that it's implied. Even the right to food is not provided for, but the African Commission in the CIRAC case has held that it's also implied. So the right to food, the right to housing, and the right to water are implied rights under the African Charter, even though they are not expressly provided for. Please see the case of Socio-Economic Rights Action Center versus Nigeria. That is the CIRAC case for short. So Resolution 550 is also another soft law. It was adopted during the 74th ordinary session this year, while that's in Banjul by the African Commission. And that resolution calls for the adoption of a regional binding instrument at the African Union level to regulate the harmful activities of business and human rights. So it's a very interesting resolution that you should also take a look at. And of course, I want to mention that there is currently a draft AU policy framework on business and human rights. I have my reservations about the draft, but I think it's worth mentioning because if it's adopted, it's been drafted since 2016, and I have participated in some of the meetings where the drafting had taken place, or the processes leading to the drafting had taken place. I'm coming to the close of my presentation, so I really apologize, but I think these are very relevant aspects. So other relevant treaties that are not actually supplementary, but they are also adopted under the auspices of the African Union. You have the African Charter on the Rights and Welfare of the Child. So you have provisions such as Article 4, the best interest of the child is of paramount consideration. So you know there is the challenge of child soldiers in some countries like the DRC and elsewhere involved in the mining industry, and companies actually benefiting from that process. So there is an implied obligation on the part of companies to ensure that, like Michelle stated, there is responsible sourcing of minerals. So what that means is that companies have an obligation, either under the UN, as they have a responsibility under the UNGPs, or an obligation under the African Charter on Human and Peoples, and under the African Charter on the Rights and Welfare of the Child, to ensure that child labor is not involved in its supply chain. So that's a very, very important thing. There is also the protection of children from all forms of exploitative economic activities and abusive economic activity, like children should not be used in child labor at all. Then also protection.
Chairman,
yes.
I'm going to ask you to quickly wrap up so that we can have a bit of time for questions.
Yes,
just in case. Yes.
Can I use the next 3 to 5 minutes?
Yes, please.
Okay, thank you. I'm actually wrapping up. But these provisions are also very relevant. So you look at provision of Article 22 of the African Charter on the Rights and Welfare of the Child, protection from armed conflict. So protect children from armed conflict. Companies benefit from children involved in armed conflict. So there's a clear obligation there. Then you have the the AU Convention on Preventing and Combating Corruption, 2003. So in that particular convention, Article 4.1(e)(f) and Article 11(1)-(3) particularly affect companies. So you can look at that. Then look at the provisions of the African Charter on Democracy, Elections and Governance, 2009, that talk about the principle of good economic and corporate governance applicable to companies. So look at Articles 3.6, 27.6, 28, 33.6, 8, and 13. And lastly, look at the AU Convention for the Protection and Assistance of Internally Displaced Persons in Africa. Now, why is this particular treaty relevant? It talks about the accountability of transnational corporations and private military contractors. But not only that, Article 10 specifically talks about development-induced displacement. So, for example, somebody talked about constructing a train station, constructing power, constructing dams, constructing roads. Many of these development projects can lead to displacement of communities, including indigenous communities. So companies have an obligation to respect human rights to ensure that development projects do not lead to displacement of people, or at all, if at all it has to lead to displacement, then there should be adequate compensation. Two cases of note cited the SIRA case, but another case that you should look at is the IHRDA versus the DRC. It's a very, very important case. Please look it up on the internet. And institutional authority. So I talked about normative and institutional. So institutional, who is responsible for ensuring that these treaties, laws that I've mentioned at the African regional level are implemented? So institutional authority of the African human rights system pertains to the bodies responsible for the promotion and protection of human rights, as well as bodies responsible for the interpretation or application of human rights treaties. So the work of these bodies can have a direct impact on businesses in terms of regulations. So I've listed a number of bodies there, starting with the African Commission where I work, the African Commission on Human and People's Rights, the African Committee of Experts on the Rights and Welfare of the Child, the African Court on Human and People's Rights, and the Future African Court of Justice and Human and People's Rights. So the Future African Court, for example, if you look at the Malabo Protocol, already recognizes the concept of corporate criminal responsibility and the possibility that corporations can actually be sued, before the future court. But the treaty is not in force yet. That is why you don't hear a lot of it. So conclusion. This is the last page I promise. The long and short of this presentation is to tell you, to show to you that the African human rights system is relevant to the business and human rights discourse to the extent that it has normative and institutional governance systems necessary for regulating the activities and impacts of business enterprises on human and people's rights in Africa. If you have any questions, I hope I will be able to address them. Thank you so much.
Well, thank you very much, Chairman, for such an informative presentation. We'll be sure to share the slides with the university so that they can send to the students and those that are involved in the mood. We'll also share the recording of this presentation just in case anyone missed anything. So I will not do much of rehashing what has been said, but I will first ask presenters to answer the presentations, the questions really that have been asked in the chat so far. And if you have any other questions, please do type them in the question and answer chat board, and we'll ask the panelists to respond. So the first question is from Daniel. He asked that, and it's directed to Darlington. There has been a problem of subverting the constitution by states, and regarding business and human rights, states or governments themselves are accomplices. The follow-up question is, how can we use the constitution to hold multinational companies accountable for their abuses, since states are often accomplices in these human rights abuses? So, Darlington, you can take that one. And there is another question from an anonymous attendee asking, Darlington spoke of a move towards drafting instruments to hold businesses directly liable for human rights abuses that occurs as a result of their profit-making activities. How effective will an instrument binding businesses directly actually be? Is it not the state's responsibility to regulate the activities of businesses operating within its jurisdiction? Should the instruments not be aimed at creating such an obligation for states, which in actuality have the true power to create enforceable norms? So I'm going to ask Chairman to respond to this. I believe this goes directly to the issue of direct liability of companies that was mentioned in both your and Michelle's presentation. So I'll ask you, Chairman, to look at this. And for Michelle, there is an issue about the issue of communist influences in terms of the background of our country. From Herbert, it's a comment, but I want you to respond looking at, does these issues relating to the political economy and the different circumstances of Africa affect how our states regulate businesses towards human rights, or affect how we deal with the issues of business and human rights? So I'm going to ask you to respond to these issues, and then take this opportunity to then give your last and parting shot, because we are quickly running out of time. So I'll start with Darlington, Chairman, and then Michelle.
All right, thanks very much, Josephine, and thanks to Daniel for the question. So I will respond as follows. I think based on how you have asked the question, I think the issue of either states being one, accomplices, or two, states actually subverting their own constitutions really is a governance issue. So where you have a state that's going rogue on its own laws, then you have only the judicial system as a recourse. And I know that the next argument then is that these judiciaries not captured as well by the state, especially the executive, as well as these powerful corporations. So if you look at a very interesting case, which of course I think can help us understand how we can hold multinational corporations to account, where we have a problem within our local systems. So basically, you're only allowed to exhaust external systems after you have attempted and failed at national systems. So let me highlight to you that we have a very interesting case that you may want to go and look at. This is the landmark case of Shell Nigeria in the Niger Delta versus the Royal Dutch Shell. So you realize that communities from Nigeria went as far as taking a case to the Dutch courts, because they thought that the courts in Nigeria were not helping much. So they decided that since this was a multinational corporation, and Shell Nigeria is a subsidiary of Shell the Netherlands, where the mother company is, they took it where the mother company is incorporated. And there was a whole issue, and the biggest fight was whether the Dutch courts actually had jurisdiction to hear this matter. And because the Dutch system is a bit advanced, the Dutch courts held that they actually had jurisdiction to hear this matter. And in 2021, the Dutch courts held that the Nigerian communities, especially these 4 farmers, were supposed to be compensated for oil spills on their land. Now, this is where we then have instruments such as the proposed binding legal instrument on business and human rights come into play. Because it is quite clear if you read on it, Article 2, which says that it is there to clarify and facilitate effective implementation of the obligation of states to respect, protect, fulfill, and promote human rights in the context of business activities, particularly those of transnational character. So I think we are going to have a clear way with a binding instrument, but nationally, we still have avenues that we can use. And if it becomes obviously a compliance issue with your state or with your government, which is going wrong on its rule of law, it becomes a rule of law issue. And when it becomes a rule of law issue, we know what to do at law. So I think that's how I may respond to your question. And of course, I will leave the second question to Chairman, which was directed at me, because I think you'll be in a position also to respond to that. I hope
Thank you.
Kamsanga has been responded to. Thank you. Over to you,
Yeah.
Josephine.
Thank you, Darlington, for that response, and also for making reference to a case that student can, Daniel can, and others can get more information about these things. Chairman, and in 2 minutes, kindly answer this. I know it's difficult, but yeah.
Okay, thank you so much, Darlington, for actually yielding this question to me, because it's actually addressed to you. So how effective will an instrument binding businesses directly actually be? How effective would it be? Okay, when it comes to the issue of effectiveness, that is usually very dependent on extraneous factors. It's dependent on the strength of the regulatory regime in a country. You know, it's also dependent on the strength of the regional or international mechanism responsible for implementing. So, for example, your question can be applicable to the current legally binding instrument at the international level. To be honest with you, there will be no direct accountability of companies at the international level under the legally binding instrument. There will be no, but there's going to be direct application of the norms, but not direct accountability. Now, there are 2 different things. One is substantive, creating direct obligations for states, for corporations, but the other is procedural. That is, can companies be held accountable? Can an individual whose rights have been violated by, say, Shell, sue before the international mechanism that's been established under the legally binding instrument? The answer is no, because the draft currently that we've seen does not allow for directly suing such companies. So even though there's direct applicability, there's no direct accountability. That's the first question. But with respect to the regional level, now there's a call under Resolution 550 of the African Commission for a legally binding instrument at the regional level. So if we can go with what we have seen in the Malabo Protocol that recognizes a possibility of direct accountability, but that treaty is not in force yet. So we don't know yet what the draft business and human rights treaty at the African Union level will be. We don't know yet, because the process is yet to commence. The resolution is a first step. But at the domestic level, to answer your question, there is direct accountability because already states have instruments. Like, for example, I mentioned Section 2, subsection 2, sections 44 and 45 of the Zimbabwean Constitution recognizes the obligations of businesses for human rights. So this means if a business violates human rights in Zimbabwe, you can actually sue under those provisions and you're likely to get judgment. But of course, it also depends on the efficacy of the domestic regime. But why is the regional level relevant? It is relevant, as Darlington has said, where the domestic system, where you've exhausted the domestic system and you're not able to get justice, you have options. So the regional level will now be a second layer. It's not to replace the domestic system, but it gives you an option. So if a state, for example, pollute with a company through a joint venture agreement. So it's both state-owned or the state has stake. If a state has stake in a joint venture, it's not likely to do anything where the company violates human rights. So this means that when you exhaust local remedies or local remedies are illusory, then you can approach a regional body like the African Commission, or if the court is empowered to do so, the future African courts, or if the international legal, any other international legal body is empowered to do so, that system. Now, the second question in there is it not the state's responsibility to regulate their activities of businesses within its jurisdiction? The straightforward answer is yes, it is the responsibility. However, like I've mentioned, if a state goes into a joint venture with a company, they are not likely to give effective regulation that is beneficial to individuals. So there will be violation, and the state can be considered to be complicit. But how do you hold the state accountable? You have to go outside the state to hold the state accountable. That's where the African Commission or any other regional body would be useful. And the last question there is, should the instrument not be aimed at creating such an obligation for states, which in actuality has the power, the true power to create enforceability? Or enforceable is not complete, but I suppose you mean enforceable decisions. I do agree that but you see, when a state fails to actually create such obligations, I mean, when an instrument does create such obligations, right? But the state does not enforce those obligations, you should be able to sue the state. But you sometimes might not succeed at a domestic level. But if you do succeed at domestic level, all well and good, so you get judgment. But if you don't succeed at domestic level, it is considered that you would have exhausted local remedies, and then you can proceed to the regional level to get justice. So I think these measures are necessary. We cannot depend entirely on the state, like I've argued in my thesis, because sometimes states are unable or unwilling to actually regulate the harmful activities of businesses. So victims of human rights abuses, either by the state itself or by transnational corporations, or even by local corporations, should be able to utilize other avenues at the transnational level. That is the African Commission, the UN treaty mechanisms and all that, to hold the state accountable for not setting up those obligations. Thank you so much.
Okay, thank you, Chairman. And quickly, Michelle, can you wrap up? I know there are other burning questions that people might have, but we'll collect those and try to answer the questions in the next edition of the webinar that we'll be hosting on this. Michelle?
Thank you, Josephine, and thank you to Herbert for the question, or rather it's more of a comment. I think definitely what you've observed is rightly correct. And because of how Africa, a lot of the African states are still, in a developing stage where we're trying to get our economies to be at a higher level than they're currently at, and also trying to get as much investment as possible. We're trying to create an investment framework where, the best, or at least a lot of investors come in. But then this is where we're saying these principles are a guide to say, when we are getting in investors or the business that then comes in, what can we do? How can we craft our laws guided by the principles? Because they are guiding principles. How can we make sure that our investor profile has reputable investors? How can we make sure that when they come in, they do what they said they would do? How can we hold them accountable with issues of transparency, issues of accountability, and even issues of the rule of law, like we've said? So it's all holistically looking at the African needs-based assessment says we need investment to be economically viable. But at the same time, that is not to be done at the expense of the human rights of the existing communities. So how do we balance that using the existing instruments, existing laws, existing policies to make sure that we respect human rights? I think that's the short answer that I can give. Thanks, Joseph.
Thank you very much, Michelle. And I would like to thank everyone for attending and asking the questions, and to our very knowledgeable and well-prepared panelists. Thank you very much for sharing your time and your knowledge with us today. I believe there are a number of questions and a number of issues that may need clarification and that may need to be ventilated further. So what we are going to do, we are also going to ask the universities to engage with the students if there are any particular areas that they need us to focus on the next edition of the webinar as we are preparing for the mood and as we are preparing for the mood and generally as we are trying to enhance knowledge on business and human rights. So thank you. We are way beyond our time, but thank you for your patience and thank you for staying connected. Until next time, bye-bye.
Bye. Thank you.
Thank you so much for having me. Grateful.
Thank you. Bye.
Bye.